This is The Law Show on CL 650. Now back to the show.
We can work it out. We can work it out. Life is very short.
Oh, we can work it out. Honest, we can. It's The Law Show here on CIL 650. Sterling Fox joined in studio by John Lakes and John White, partners at Lakes White LLP, a North Vancouver law firm in the estate planning, estate litigation, and wills category. And we've been talking a lot about, the law teaches us in many ways how little we know. And for example, we all assumed, John White, that we knew what spouses and children were all about until we started talking to you guys and the definitions within the law, especially as the court views them with respect to being eligible to receive goodies in the will. Man, that definition changes in a big hurry, doesn't it?
Oh, there's all sorts of ways it can change. Sorry to muddy the waters, but they were never really as clear as we thought they were.
Right. Well, I think speaking of clarity, let's spend a few minutes on getting it right in the first place. John Lakes, you told us last month when you were visiting that you don't like the term a simple will because you just don't think there are many such things.
Well,
why is that?
Well, everybody's has different circumstances. So, for example, when you do a will, you may have to look at other documents as well. So, for example, you may have a business where you've got some sort of shareholders agreement or partnership agreement creates obligations on your death. You may have a separation agreement.
So the will has to acknowledge that you have this business arrangement.
That's right.
Okay.
Or you might have a separation agreement or with a previous spouse. So you may have a court order that affects assets, or you might be party to a family trust, or you might be in the process of receiving a windfall. So you might be getting some money from great Aunt Mary, and you may want to make a provision for that. So will doesn't always stand alone. And it may be affected by other obligations that you've got to other people, or may be affected by things like RSPs or life insurance where you've got named beneficiaries as well. So you've got to make sure that the will fits into your overall planning and your overall obligations to other parties. So for example, if you have a business where you might have a key man insurance where your partner, when you die, gets $500,000, so part of that goes to him, but the other part goes to your estate. You've got to make sure that there's made provisions for that. So the will has to cover current situations as well.
So it isn't simple in most cases. Now, if you're an employed person working on a salary for the same company for 40 years, life is, relatively speaking, uncomplicated, staying away from the simple word, and you don't have a lot of attachments or connections to the business world. Is a standalone will, under those circumstances, in and of itself adequate?
Well, for a lot of people, I mean, a standard will may be they leave everything to their spouse. If something happens to both, they may name their brother as executor, and they have the right to sell all your assets and pay off your bills. And then you may want to keep everything tied up to the youngest child is 25. But then you get into issues like what happens if the whole family is killed? What happens if one of your children is involved, has some mental health or has some issues? What happens if your child's a $5,000 a month hockey player? I mean, it's and then you need to name guardians. So for a lot of people, things are relatively simple, but the lawyer has to make sure it is simple before we do what's called a simple will. So, and as I say, you've got to look at the scale of your assets too.
Now, John,
so sometimes the smallest estates I have are the most complicated.
Okay. So size really is almost irrelevant.
Not always.
John White, when you go to court and you deal with a lot of challenges to wills, and you were telling us last month that in some cases there's one rival group of siblings or children, dependents, of battling the other group for more of the estate.
Sure.
But in many cases, people challenge whether the will is even valid in the first place. What would the reasons that a will would be declared to be invalid?
Well, this is part of the probate process that we talked about last month as well. And on occasion, these cases go to court where you have to prove that a will is valid, or perhaps you're trying, if you're on the other side of it, to prove that a will is not valid. But an example would be that the will maker didn't have what we call testamentary capacity, that is, the mental capacity sufficient to make a valid and binding will. You can, as John talked about last month, it can be too late to take instructions from someone who is dying,
had a stroke or something,
who has had a stroke,
Right.
or is suffering from dementia,
right?
and simply doesn't have enough mental wherewithal anymore to give proper instructions, to understand what they're doing in terms of giving away their property after they die, not understanding what property they have to give away, not understanding perhaps who they ought to be giving it to, or at least ought to be thinking about. Tests like that are tests of what we call testamentary capacity, and one of the first things that a lawyer should be doing when writing a will is to make sure that the person that he or she's taking instructions from has the mental capacity to give those instructions.
And John Lakes, that's part of the ethics of your practice of law, in that you lawyers are duty bound to ascertain that someone is competent and capable of drawing up a will as you prepare it for that person.
And we also have to make sure they're not under undue influence as well. So you could have somebody who's competent but may more or less be coerced. So, for example, the daughter takes mommy to see a lawyer, and the daughter says, well, if you don't leave me this, you're not going to see the grandkids. So we have a real obligation that the wills we do, we have to more or less confirm that the person is competent, they understand what they're doing, and second of all, they're doing so freely and voluntarily without fear of intimidation.
Right.
So, and unfortunately, that's now, if a will is done by a lawyer, there's a presumption that a lawyer is not going to risk their legal career based on one will.
Mm-hmm.
But however, if it's one of these self-counseling press books,
Or some
where
internet do-it-yourself kit.
where the two witnesses are the next door neighbors
Right.
who've never seen anything, then those are subject to attack. And so there's no, I mean, quite frankly, sometimes it's hard when I have people come in and with their mother, and I say, well, I'm sorry, it's too late. I'm not going to do this will, because they would sign anything I asked them to.
Sure, sure.
So again, that's why it's important for people to do wills when they're capable, rather than, sometimes even if it's really what they intend to do. But when I see a client to see a will, I kick the daughter, kick the son out. I have to see the client there by themselves.
One-on-one, exactly, yeah. The importance of getting it right in the first place. Our guests, John Lakes and John White from Lakes White LLP in North Vancouver. We're talking estate planning and wills on The Law Show here on CIL 650, and we're back with plenty more after this.
There's more of the show still ahead. This is The Law Show on CIL 650.